and choosing our panel. Thanks also very much to the organizers and ILITA and everyone who's been associated with this wonderful conference, which I think we can all agree has been excellently organized. So thanks very much for the invitation to set this panel up. It's now the second day of the conference, and we have saved for not almost last, but close to the end, one of the most difficult, intractable sets of questions in the whole of data protection and privacy law, which are which laws apply to the processing of personal data, which entities have jurisdiction over the processing, and I should say those two questions are not necessarily identical and they can have different answers, and how and where can determinations by regulatory authorities, courts, or private parties be enforced. These questions are the topics that we're going to deal with today. These questions, while very important, I think are also difficult to discuss in this setting in a theoretical way. So we have decided to base this panel on a fact pattern. We're going to do it a little bit differently. You should all have in front of you a copy, just a one-page copy, which has the facts of the situations which we will be discussing and some of the questions which we will be discussing. So I would ask you to look over that closely and refer to it. And we will be doing some role-playing here today, as you will see. I will introduce everyone here in a minute. My role in this panel, I'm Christopher Cooner of Hunt & Williams in Brussels. My role will be that of the general counsel of a international consumer company which is faced with many of the questions in conflict of laws which come up quite often in practice. And my colleagues will be advising me. These are colleagues that I've assembled around me. You can see that I have first of all, I have a very big budget because I have two partners, two very expert, famous partners who practice data protection law. I've also been able to bring a lawyer, in-house lawyer from one of the largest financial services companies in the world, Citibank. We have someone from an international organization. And finally, someone from the Spanish Data Protection Authority. You can see I have a lot of trust also because I'm not worried about bringing in the Spanish DPA to discuss my problems with them in advance. I know how helpful they can be. You will see that the facts are quite limited, so we're going to have to use our imaginations and make things up a bit, but I'm sure we can all do that. A couple of things about this panel. I will be jumping in, playing the devil's advocate a bit as we go through discussing these different questions with my colleagues. We will also try to suggest solutions, so I think the problems here are obvious. Probably you've all dealt with them in one form or another in whatever capacity you work in, but we're going to try to suggest some ways, if possible, to cope with them. We also want to leave time for questions, certainly questions at the end, but also questions in between. So as we go through these four questions that are listed on the piece of paper in front of you, we will also be asking you to raise questions, and please raise your hand so I can choose you, and don't just yell out a question if possible. And I would appreciate it too, before you state your question, if you could identify yourself and what organization you're from. So with that, I would like to first of all introduce our four panelists. We have Locke Morel to my left, who is a partner at De Brouw, Blackstone & Westbrook in Amsterdam, a very well-known practitioner of data protection and IT law. As I said, Vivian Arts. Next to her is the managing director of the IP and ONT Law Group and head of international at Citigroup in London. Thanks for being with us, Vivian. We were to have Ruth Boardman from Bird & Bird, who unfortunately had to cancel at the last minute for family reasons, but we're very, very fortunate and grateful to have as what better replacement could we have than Ariane Moll, a famous French data protection lawyer, partner of Bird & Bird in Paris. So we really appreciate you jumping in like this, Ariane. And then we have from a very important international organization, the Hague Conference for Private International Law, Micah Thorner, who's a legal officer there and also has, in her previous existence, has practical experience as a data protection lawyer. And finally, someone I think we all know and greatly respect, Rafael Garcia Gonzalo, head of the international office at the Spanish Data Protection Agency. With that introduction, I'd like to turn the microphone over to Raphael and ask if you'd like to make a few introductory comments on this topic, Raphael.
Yeah, thank you very much, Chris, for your kind introduction. And I would like also to thank the organizers of this conference, my colleagues from the Israeli Data Protection, for offering us the opportunity to be here today. Well, I'm afraid that I'm the only regulator here, so I'm surrounded by practitioners, experts, and I'm afraid that my role here will be that of not the devil's advocate, as Chris said before, but that of the regulator. I mean, our main purpose is our aim is protecting the data of our citizens. So that's sometimes it is not very helpful. So perhaps we are also looking for answers and not giving answers sometimes. I have the impression that the main problem that underlies this session and the topics that we will be addressing is that most of our laws are based on the idea or on the assumption that we are making quite simple and clean transborder data flows from one country to another. This happened 20 years ago or 30 years ago, or even closer in time when most of our laws were developed. But the situation, the real world, is not like that. Today we see situations which are completely different. Global companies with subsidiaries all over the world which are collecting data in different subsidiaries and moving data among these subsidiaries and headquarters and with two other companies. So this is perhaps, I think this is one of the problems. And the other one is that we are talking about data protection, but data protection does not exist in an isolated world. It has it coexists with a number of laws or regulations or legal frameworks that apply to other fields, but which are closely related. And today we'll have the opportunity to discuss how the relationships between these laws or legal frameworks are. And sometimes it may be that I would say that we may have problems or difficulties or conflicts, as the title of our session goes, at two levels. One of them is when looking at it exclusively from the data protection perspective, conflicts of laws in different countries, in different jurisdictions, but at the same time, along with it, we also may have conflicts of laws with laws or legal frameworks which are run or go in parallel to data protection. So perhaps I should say here that my role here would be that to uphold the importance of data protection legal framework, even taking into account the importance of other legal frameworks and also taking into account the fact that in some of our countries, or in some countries, there are the connections or the relationships between these different legal regimes are solved in a formal way. There are clear criteria to apply one or the other, or to which one has priority over which other one. Perhaps that's not the case in other countries, and perhaps that's one of the problems. The big, or perhaps not that big, differences that legal regimes in different jurisdictions have. So, as I say, I'll be here the regulator, the watchdog of data protection from a data protection perspective, and also I will try to sometimes to mention or to try to mention some elements to show that data protection authorities are not only watchdogs, but sometimes we come up with solutions and some of them have recently been adopted or put into place. So that's all. With that, I think we can go into the case.
All right.
Thank
well,
you.
Thank you for those wise words, Rafael. And we will indeed be turning to you, I think, throughout this, the discussion of these different issues. So let me first just set the stage and sort of paraphrase a bit the situation here. You have this in front of you, but I need to introduce myself as the one who's assembled here, my colleagues. You know, as I said, I'm the general counsel of a company called International Consumer Company. You can see how much money our marketing department spent on choosing our name, which is a multinational company that sells consumer goods. Now, we have our headquarters in the UK, and we have subsidiaries in many EU member states, but also in China, India, Singapore, and the US. The main servers through which most of our data flow are located in the UK. However, I've recently was talking to the head of our IT department who told me actually some of our local subsidiaries have, of course, not only their own PCs, but their own servers and their own databases, which I didn't know about, and I was a bit shocked to hear. And frankly, because all of this data protection was so new to me, it's something that we haven't dealt with really in this company before, so we don't really know very much about how we process data, what sort of data we hold, the purposes for which it's processed. But this is the reason we're here now. We're going to embark on a compliance exercise to try to get more information about these points. We do collect employee data directly from employees. We have a centralized web tool from an employee database that goes to our UK servers, but again, I've learned to my disquiet that some of our local subsidiaries also seem to have their own employee HR data systems. We do collect consumer data. The company has different web projects, and we collect data through the websites related to those projects, some of them that are the headquarters host or that the subsidiaries host. And then, of course, we also have to collect data from vendors and business contacts as we do business with them. So I have become more and more concerned about the conflict of laws issues with data protection as I've been convinced, much against my initial resistance, to embark on this project, having so many other compliance issues that our company has to deal with competition law and environmental law, etc. But I said, all right, we have to do this data protection stuff. So I've assembled this panel really of experts to help me sort of to go through the issues. So I'd like each of you maybe to just start out by giving me a 5 or 10 minute introduction to the issues on some of the problems which I've selected here for your consideration. And I'm going to turn first to Locke. Locke, first of all, to just describe the situation a bit. We're beginning this e-commerce project in the company, and we will sell goods online from a website which the headquarter in the UK runs, both all around Europe to consumers, but also to consumers in Russia. We see that as a growing market for us. And we need really to know which law applies to the project. I've spoken to my in-house lawyers. They can't give me a clear answer. Then also the head of our marketing department has come up with a brilliant idea. Of course, as part of this project, we have to market it to consumers. And he said that he heard from someone that if we just move all the European data to Singapore and send the emails, the marketing emails to people in the EU from Singapore, we can get around all of these EU data protection restrictions. So I'm really hoping that this is possible. And I'm turning to you also because I know that you just published a lengthy article on these topics in what is probably clearly the leading data protection law journal, International Data Privacy Law. So, Locke, with that introduction, can you edify me a bit?
Totally happy. Thank you, Chris. Yeah, so we're talking about a UK headquartered company that hosts a website and sells consumer goods, and the consumers are in the EU all over the world, but let's focus on the EU for a moment. And direct emails are also sent from Singapore. What I like about this fact pattern, and that's taking a bit a step away, is that we talk about privacy a lot, but if you look at this fact pattern as a lawyer, you immediately think all over Europe we have to look at the e-commerce laws, we have to look at the privacy data protection laws, but also separate laws regulating the use of cookies, the use of or the sending of direct emails, and also you have the distance selling requirements in the European context. And I have to note, and that is a bit of a bugbear, that if you look at all those 4 laws in all the different countries, they have different applicability regimes and jurisdiction regimes. So, if you take the EU example, and I just go through it quickly, not so much for you to memorize it all, but just to show how different they are. If you look at the e-commerce laws, we have it's the UK headquarter. We have a country of origin principle there, which means you have to apply the UK e-commerce laws to that website, and then you have a passport for Europe. But exceptions are, don't know whether anybody knows them, but it's spamming, so direct email, it's data protection, and it's consumer contracting. So there you go, the other 3 laws I just mentioned. Data protection. When are the laws applicable? If the data are processed in the context of activities of a European establishment. Well, we do have an establishment in the UK, so there you go, the UK laws apply to all the data processed in the context of the websites. Spam, direct emails. The e-privacy directive has its own applicability regime. It applies to whenever you send an email to an EU citizen. So if it's a Dutch person, Dutch law applies. If it's French laws applies. The distance selling directive has its own applicability regime, and it applies, there's no country of origin principle there. It applies whenever you contract with an EU consumer. So having one website triggers 4 laws in nearly all countries, and my real point here, before I'll give you a bit of a steer how we can deal with this, but if you take and diving into the data protection directive for a second, this directive was drafted from the perspective, which was a bit of an alien situation, that you want to protect EU citizens. But by doing that, you needed to actually to protect data being transferred outside of Europe. That was the basis.
Maybe move the mic a little bit farther.
A little further? Okay. Is this better? Okay, thanks. Thanks, Chris. So it's protection of data going outside of Europe. Now we have websites where, like media, advertising law, that is actually, coming outside of Europe sometimes, and you want to protect citizens when they're confronted, so they are targeted in their country. So things have moved on since we enacted the Data Protection Directive, and the laws, the applicability rules need to be revised from that context when you actually have the situation when websites are addressing people in Europe. And that is what the article is about, to try to revise that. And why am I pointing that out is that I think the new technologies are more like the media law, are more like the spam laws, the cookie laws that have a different basis. And I think we should bring the directive more in line with that, because data protection is not an isolated topic, it's a topic that has to operate within a context of other laws. So if you look at the present situation on direct emails, etc., I think the present interpretation of the directive is a bit too broad. That's what the article is about, and it's indiscriminative, because it applies whenever you have a cookie, and I think we need to bring it more in line with the existing laws and jurisdiction rules on, like media law, when it applies when you actually target somebody in a jurisdiction. So here you go, in our setting, for the e-commerce rules, you can look at the UK for data protection. We're going to look at the UK, but having worked with companies, doing a one-set-all consumer contracting contracts, one-set-all requirements for cookies, it is possible to do that. and it needs some tweaking here and there, but it is possible, but it is quite an exercise. And having the DPA here, I think if you look worldwide and not just to Europe, the gaps in protection are far more challenging in countries outside Europe, that the little differences between the different countries are, if you look at the worldwide picture, if you have a company like ours, the differences are so small in Europe that actually I think it would be a very good step to stop nibbling about the little small details within Europe, but go for a country of origin principle for all kinds of topics here in Europe, and maybe even when you have adequacy rulings, accept each other's adequacy laws in that respect, so it will be more easy for companies to comply. Because with the things, this is a simple website, but the things we see coming, my expectation is that if we keep on talking about which law applies in Europe and all the little small differences, we might miss the bigger picture, which is providing material protection for our own EU citizens. Maybe.
Well, this is very reassuring, Locke. I really appreciate that clear exposition. And it seems to me from what you're saying that we can serve this website from the UK to different EU countries, and it will be governed by UK law under this country of origin principle, which is great because I know UK law, I know it's a bit more business friendly, etc. So that's great. But I'm looking at my friend Raphael, and I just wonder, from a DPA perspective, how do you agree with that, Raphael?
With what exactly?
Well, let's say you have a consumer in Spain who is going to take part in this in this project, and so they will go onto this e-commerce website and take part in it. And then let's assume, which I'm sure won't happen, but there may be some sort of data protection dispute, and their rights then will be governed by UK law in Spain. Is that something that you would accept?
We would, because it's a fact. I mean, the fact is I would tend to agree with what Locke said about some, I would say, collateral or damages of the European legal regime. One of them has already been described. A colleague of mine who is somewhere over there always refers to another example, that's of an Australian company dealing with Australian citizens' data, but which happens to have a server in the European Union. So it's European law, the one which will be applied. So this is also something which is not probably the best of solutions. But at the same time, that being said, I think that we all need criteria, I mean, in a way or another. Probably the fact that we are referring this criteria to national borders is something which is outdated or which is not perhaps not the best solution today, but well, it was a solution, and it's still a solution. That's the way in which the applicability regime of the directive was devised. And in fact, I would say that some of the evolutions or of the interpretations of this applicability regime have been difficult, or have been an answer to try to face the challenges of let's say, the digital era. I'm talking about cookies, for instance. But well, of course, we would accept the situation that Spanish consumers' data would have to be regulated by British law. Perhaps I should I should add to that, well, one of the answers to, or one of the possible answers to this situation is that of the cooperation of data protection authorities, both within Europe and elsewhere. because again we are talking about laws and powers and functions that are confined to a national territory, but at the same time we are talking about issues that are transborder in nature. So the answer would be yes, I would accept that, and perhaps I would seek the cooperation with the British ICO.
Okay, well, this is wonderful. We already have such clarity. One thing I noticed, though, Locke, isn't there a bit of a contradiction between this web scenario and the email scenario? Because it seems in the web scenario, my company can have a single server in the UK, and the applicable law will be judged by the country of origin. But if I want to send these emails into the EU from Singapore, why isn't this all judged under the law of Singapore then?
The protection principle ruled when enacting the e-privacy directive, and whenever an email is sent to an EU citizen, the law applies. So it doesn't matter where it's sent from, whether it's Singapore. It doesn't help bringing it over to Singapore to actually avoid European laws. And this would be one of the topics, I think, if all the member states now having more or less similar spamming rules, why not say, you know, it will be UK law also for that, and actually have it sent from the UK and have as a benefit that that is just governed by UK law, but you know where the company is, so it's easier to prosecute rather than go after them in Singapore. So give them the benefit of one applicable law and have, you know, a good redress and you know, a company to go after. That would be my solution for the future.
Well, that's great. I knew that this marketing director must have been wrong. I have to talk to him. He's always coming up with these crazy solutions. And Raphael, this enlightened view, is this something that that say a consumer in Spain that accesses a website from the UK can comply only, or their rights will be judged under UK law? Is this something that your colleagues in the other DPAs would all accept? Is this a common position already?
Yeah, in fact, in fact, there are several. We have several cases in which this has happened. I mean, citizens from other European countries which had difficulties that, for one reason or another, had to be dealt with in Spain, and the situation has been solved, as I said before, via the cooperation between the Data Protection Authority in that country and the Data Protection Authority in Spain, or vice versa. So I think it is a situation that now we are confronted with. I wouldn't say that very often, but not infrequently.
Very good, thank you. Do any of my other colleagues want to add anything to this situation? No.
Sure.
Yes, Micah.
Well, Raphael, I wonder if your opinion would be any different if the country at issue was not the UK, but was instead a country without an adequacy finding, such as the United States. So you said that you would recognize the United Kingdom as the applicable law, and I'm wondering if your opinion would be the same if, for example, it was a country that didn't have an adequacy finding, such as the United States.
Well, the fact is that here we are talking about something which is regulated by the directive, so which in a way defines the obligations and the responsibilities and the applicability regime of data protection laws within Europe. It's true that there are some provisions which are related to situations which I would say are borderline, which are not completely outside Europe, but not completely inside Europe. But with the situation that you referred to, is not exactly mentioned in the directive. But the fact is that, again, it is the truth. I mean, of course, there are different possibilities. But say if we talk about, for instance, spam, which is in Spain, that's one of the cases. It's also in our law, and this is one of the examples in which data protection law and other legal regimes are coordinated, so to speak. In spam, as I say, we applied that very same regime. I mean, our law, it's not data protection law, it's our law on information society services, says that this is related to data protection, but that the legal regime which will be applicable will be that of Spain whenever the spams are sent to a Spanish citizen. So this is well, this is the legal regime as it is, and that's the situation.
Okay, any questions from the floor on this topic? It's crystal clear. Yes, ma'am.
I'm not sure I got the answer. Would it be yes, you would accept the law for the U.S. or no?
No, but no. Thank you. No, I'm not giving a concrete answer, because in fact I should know exactly what the situation is. Because of that, I was referring to the example of spam, which is quite a clear one. Of course, you would have to do it, for instance, situations in which, according to the European regime, the company in I don't know what, United States company has, for instance, in Europe, means for processing data that would make European law applicable. That would be a situation in which I would say no, I wouldn't accept the American regime. So I think this is the question is complex, and the answer is complex too. But depending on the situation, the answer would be yes, would be perhaps, would be no. But in these two examples.
I'm already seeing the clouds are starting to roll in again, the lack of clarity. We have one question from the floor before we go on. Yes, ma'am, could you?
Sorry, it was sort of, sorry, Janine McCall from Warner Brothers. It was sort of the same question. So you're saying if we try to harmonise all of these laws, country of origin would work, provided it's country of origin in the EU.
Yes.
You're not prepared to look at country of origin outside of the EU or harmonise with countries outside of the EU.
How the country of origin principle works in e-commerce? Yeah. Yeah, that is. Yeah.
If we try to standardise these laws, we would be prepared to accept country of origin, provided it's only country of origin within the EU.
No, thank you for the question. What I'm saying, again, I said that at the beginning, and I say it again. I'm not talking about the let's say, commerce perspective, or I'm talking about the data protection perspective. And so it's difficult to find a clear criterion to decide which legal regime apply. In fact, we are discussing about that today. What I'm saying is that we have a legal regime as described by the European directive, which applies within the European Union and mainly, I would say, regulates the applicability regime within the European Union, with some provisions for data processing which take place, let's say, totally or partially within the European Union, but so, as I say, not completely within the European Union. So the possibilities of harmonizing this regime would have to be considered in the framework of the revision of the European directive, because it is as far as we European regulators are concerned, it's let's say, our legal framework. I think that the harmonization at the global level is something which is bigger. And then, if we talk about this harmonization at the European level, well, of course, there are different possibilities, but I think that you have to be careful when you look at these criteria, because sometimes when you open a door, you close another one, or when you make a decision, trying to solve a problem, you may open a new one.
Yeah.
So it's okay. So far, let's say the territorial element is what we have, and it may raise some problems, and it may open new issues, open new questions. But it's something that in many cases works. So I think that we have to be careful if we start thinking about other possibilities, other criteria.
Well, thank you for mentioning the territorial element, because this leads in perfectly to a scenario we have which seems to do away with territoriality. And I want to turn to this to Vivienne as someone from a large global company, and I'm sure this is probably something that's crossed your desk. You know, we're building this large database to hold all of our employee data, and I'm very, and our controller is also very hot on using a cloud computing service provider to do this, because there's such a large cost savings, and we've identified someone. So this provider has told us that they have servers in the US, Slovakia, China, and in those 3 countries. So I've had some problems with works councils who don't seem to like China and the U.S. as a place for the data. Slovakia, they're not so hot on, but they seem to accept it more or less. So I'm wondering, can you give us some information, or what is your view on which law would then apply from a data protection point of view to these data, which are then going to be in the cloud?
Chris, you asked some very interesting questions, but let me start off by saying I don't think it's a cloud, I think it's a fog. I live in London, and this is a pea souper. Yeah, definitely. Huge group of issues. Now, I'm sure your technology people have explained to you all the benefits of using your cloud supplier, and that the cloud model is going to solve all of your problems. It's going to consolidate your data. You can get rid of all of those different employee databases that you said you had dotted around. You had the one in the UK, and you had different countries holding different bits of data, probably different in different ways, different levels of security. So this is going to be great. You can put it all together. It'll be in one place. You can readily access it. And you can probably use some more up-to-date technology as well, because I think you've just been developing this new database. So you can get consistency of data. You can probably use a bit of privacy by design, and make sure you get the right information in there, not too much information. It's going to cost you a lot less as well, isn't it? I mean, having it in one place as opposed to all over the place, all those people supporting it, and now you only have to have one set of in fact, you don't have to have anyone supporting it because it's a cloud supplier, isn't it? That's going to be superb. And you're going to have this immediate access as well, because I bet it's going to be available 24/7, so you don't have to wait when they brought it down for maintenance on the weekend, and you're trying to do your end-of-month payroll run, and there's a bug, and they have to fix it, and there's that and the other. I mean, this is an online, on-demand service. So, I mean, this actually sounds like it might solve all of your problems. But anyway, I hope you have a lot of time and a big budget, because we're in the fog here, and it's going to take us a while to find our way out. So for all of those fantastic benefits, we have to remember that the data is going into the cloud, and the cloud is, I suppose, kind of like the internet. Is it as different as software as a service? Not so much, but one of the interesting things about the cloud is that your data ends up in the cloud, and now you found out that it's not really in one place, is it? It's actually going to be in 3. So there we were thinking, oh, it's in one place, one set of laws and regulations. And now we're thinking, oh, hang on a second, it's the US, it's Slovakia, and it's China. And I put my data privacy hat on, and I'm thinking, ooh, now how many of those jurisdictions is there an adequacy finding in relation to data privacy? Because if there isn't, we're going to have to go through a whole bunch of hoops to try and make sure that everything is going to be appropriate from a data privacy point of view. So, we're going to have to think of a few things. I'm not an employment lawyer, but you may want to get your employment lawyer in here. This is why you need all this budget, okay? So, because employee data isn't quite the same as customer data. And, with a customer, you could go and you could be transparent with them, and you could explain to them that you're going to use third parties to host their data and so on and so forth. But, the employees, consent doesn't always work. And the other thing about consent, I'll just tell you this practically, is if they don't give consent, what's your plan B? Yeah, this is a tough one. And I mean, let's face it, you don't want to go back to that old model of data sitting everywhere, et cetera, et cetera. So we've got to think quite carefully, because these are employees. You're also going to think, who's your controller here? Okay, because obviously you should be the controlling entity, but who's been collecting the data and sending it into the cloud?
What is this controller? What do you mean? You mean my financial controller, or what?
Well, I think you need to speak to him too. But it's this foggy European concept of controller. And you know what? This controller concept is kind of mushed up with a processor concept, and this is quite complicated. And there really isn't a whole lot of clarity. In fact, there was this very interesting incident a couple of years ago with regard to a company called Swift. And boy, did we have trouble considering, who's acting as a controller, who's acting as a processor. Basically, the technical definition is that a controller decides the purpose and means of processing. But, this is HR data, and I think you've developed the database service, but often people get an HR provider to host. And then the whole definition of are they a processor or a controller gets a little bit more clouded, because, you're probably the controller because you're the employer. But is that your UK entity? Is that your individual entities and all of your subsidiaries? So have you got multiple controllers? Are you the controller together with whoever it is who's operating the system? Then you've got co-controllers, and they're not even in the same company. How are you going to divvy up your responsibilities here and liabilities? Because somebody's got to tell the employees what's going on. So this is a bit scary. So we're going to have to try and figure out, the employee issues and the controller issues. Swift ended up in a bit of a mess on this, actually, but I think all's well that ends well. The other thing you're going to have to think about now is governing law and jurisdiction, because so far we've got all the countries where the data originated. So I understand you're in most of the EU states and a few others, and now you've got your cloud provider, and they're based in 3 different countries as well. So, which governing law is going to prevail? I think you need external counsel for that.
There goes my budget.
But what you might want to think about, though, is that the laws are very different, and sometimes, particularly in the employment environment, foreign law can give rise to unexpected, binding, non-contractual obligations, such as duties of good faith and negotiations. And this is because, for example, you're dealing with employee data, or if it was consumer data, again, additional obligations may arise that even though you've sorted out your governing law and jurisdiction, maybe you specified it in the contract, etc., but these local laws will prevail and override nonetheless. So you have to keep your eye out for that. Another one would be, for example, defamation law. So that's quite something. Now we talked about that controllers and process, and I don't want to go too far down that road because it does get a bit spooky. But the other thing to think about really is this a transfer of data, or is this a sharing of data? Because a lot of the existing data privacy legislation looks at transfers, sort of, from A to B to C, and they've got these lovely model contracts that you can use. But you've got your cloud computing provider, and in fact they're in 3 different locations, and I'll bet they're all different legal entities as well. So you're going to have to think carefully about your model contracts here. And it's less of a transfer, if you think about it, in the cloud, and it's more of a sharing. It's that kind of nebulous thing, because you kind of put your fingers in and you pull the data out, and you've no idea where it's been. Is it stored in the 3 different places at the same time? How many times is it being duplicated? All this kind of stuff. So it sounded kind of cool, but it's sounding kind of scary now as well. We can go on forever, actually, on this. But the difficulty is that you as a company, how are you going to resolve this issue practically in relation to your employees? Yeah, so we're going to have to take a pragmatic view. Now, if you're going to sort it out practically, I don't know that you can comply with all these relevant laws at the same time. And this is where I think we would look to our regulators and say, we've got conflicting laws here in relation to data privacy and other bits of legislation. And we think of the Swift case where caught between a rock and a hard place. There was Swift. They had a data center in the EU, data center in the US. In the US, they were issued with a subpoena to reveal some of the data. They went through a due diligence exercise. They put in place controls. They had to balance up, maybe data privacy says we shouldn't disclose, but if I don't comply with the subpoena, they're going to put me in jail. And they supplied the information, and then they were found to have breached data privacy law. And I think too many organizations are left between a rock and a hard place, having to make those decisions without any clarity from a legal and regulatory perspective. And so, Chris, I think you need to pay your money to your industry body and start lobbying the regulators to provide more clarity and to help businesses out in these difficult situations, because we're not often we can't change the law, and being left in that difficult position where you're balancing, it's a huge risk. And who are you going to disappoint?
Well, it sounds like we have indeed entered the fog. We've moved from the light of clarity into a very thick fog, and I'm almost. I appreciate that, setting forth the issues, but I'm almost more confused than when we started on this cloud computing. I mean, it does save a lot of money, but there's so many legal issues. And for example, maybe you can help me with a practical question. We get all of these employees, particularly from Germany, asking for access to their data. And now I'm thinking, well, if the data is in the cloud, so it may be in China, etc., which law then do I have to comply with? Do I have to comply with the German law for that where these employees are? Can I just tell them, no, this is in the cloud, or it's in China, so there's either no law or there's Chinese law?
Well, it would be tempting to say that it's in the cloud and go and find it yourself, but that wouldn't be the responsible thing to do. So you're going to have to work with your Works Council on this, and ultimately they're your German employees, so you're going to look to your German employing entity, and we're going to come back down to the whole concept of who is the controller, and really the logical place to start would be with the employing entity. So let's look to the employing entity and suggest we should have a policy on this, Chris. That would be a great idea. Maybe a policy and guidelines. And we would say that if you do want to access your data, go to your employing entity and ask for it. And then, of course, your German employing entity is going to have to run off to London and say, oi, where did we put the data? Who's transferring it? Did it transfer directly from the database in the UK to the cloud computer? Or have we uploaded it all now and it just sits out there with a third-party service provider? And hope to goodness that you've managed to negotiate some decent terms and conditions with that service provider, because some of these cloud computing providers have got very strict terms and conditions that they don't negotiate well on. So you're going to have to run off to your cloud computing provider, check the terms of your contract, and make sure that you've got some provisions in there, which means that they will provide you with that information in a timely way so you can comply with your obligations to your employees. Because remember, you don't outsource your responsibilities. So you always continue to be responsible. So although you've sent it out into the cloud and it's technically out of your physical control in many ways, you still have to exercise all the legal controls of that data.
Well, those are very useful practical tips. Thank you. But Raphael, I really hope that you and your colleagues in the DPA community are going to look in this issue of cloud computing. And I've heard this word accountability thrown around. I don't know how this all fits together. Can you say something?
In fact, I was thinking about something which is in a way related to accountability, and it's when you look at the case that we are considering, not looking at the separate points, but looking at all of them together, and particularly at this one, the one of the global database. Perhaps as regulator, not being, for instance, not being the Spanish regulator, but the British regulator, I would perhaps suggest you to consider the possibility of applying for the authorized, having a BCR authorized. I mean, well, it is here. I say that because here we are looking at the one element of the whole case, which is labor data or data related to labor relationships. But we also have many other flows of data. You referred at the beginning of the example. Also consumers, vendors. We have subsidiaries in different places, both inside and outside Europe. So it looks like the typical case in which perhaps BCR would be something useful. So it's and well, as you know, the elements of BCRs include an element. BCRs include an accountability dimension, which would be perhaps related to what you said.
Well, I heard the word BCR, and I immediately thought of Locke. So, Locke, do you have any thoughts on that?
Well, I think the BCR is a great idea for solving, the internal issues of your company, because you have a central database and you have companies also outside Europe, so that would solve your transfers there. But we have also the cloud, provider, and there the data goes outside of your company, so you will have a transfer problem there. But, well, things have moved on also in the cloud, and by now the first big deals have been entered into, and you have quite some leverage because you have a big HR database, you're quite a big company. So some of the big providers have actually thought about centralizing their cloud more to Europe or in adequate countries and not having part of their cloud also in the US. And even companies that you wouldn't expect being willing to do that have been localizing their cloud, and I dare say that the ones that actually manage that are the ones who are actually going to make most business out of this. So my advice as outside counsel would be to go into the negotiations with a straight back and say, look, I've done my BCR for my internal transfers, and I think you should have a solution for yours as well. Why not localize it in Europe or in adequate countries?
All right, and yeah, I'm assuming doing BCRs is probably not that expensive also in terms of counsel fees, or it's a fairly quick process too, so.
It's easy.
Easy, yes, all right.
Well, given the fact that you have all those databases around Europe now, which are completely compliant, having all your filings in place, all your employee notifications, you're already auditing already for a long time on privacy. You've had everybody trained on privacy. I think PCR is actually more of a codification of your efforts till up to now. So, it will be a bit of a tuning and tweaking for the central database, but I think you're fine.
All right. Yes, Raphael.
Yeah, I would like to add to what Locke said. Of course, it's true that BCRs regulate in a way the internal relationships between the group, but that in a way would help to solve part of the problem. You were referring to the different legal regimes applicable to the collection of data, and also to the the complications or the difficulties or the complexities about the definition of who's the controller, depending also on the structure of this global database, as you explained. So BCRs would be perhaps a way to solve the first part of the problem. This would help to organize this first part of the problem. So the second one, well, of course, this is again, Chris referred to accountability. We can also here refer to again to another instrument which has been recently developed, also with limitations, which is the standard contractual clauses controller. I was refraining from using the word controller, which is the European legal term, controller processor. And it's true that it is something difficult because we don't know where the service provider is. I mean, the company as such. We know that the servers are in other locations. So perhaps these standard contractual clauses would not directly be useful, because that wouldn't be the case if the first let's say processor is within Europe, unless the the company, the UK, allows for the application or subsidiary application of the standard contractual clauses to a situation in which the first processor is within the European Union, something which is possible according to the EU decision, to the Commission decision, but which is not a part of the provision as such.
Okay, Ariane.
Yeah, if I can add something, since we're talking about cloud computing and BCRs, we see that in that example, if the processor is outside, if the processor is outside of the group anyway, the BCRs are not going to help because the BCRs are not going to cover the processor outside of the European Union. So a good way of using BCRs for cloud computing would be if BCRs could apply to companies selling cloud computing services, and in that case they would have BCRs for all their entities, and if as a controller, Chris, you would refer to an entity, to a processor with BCRs as a processor, then you would solve your problem. So it's an interesting development it could be an interesting development for BCRs.
Sounds very good, yes. And maybe we have a couple of questions to this scenario, and I see, first of all, someone with needs no introduction, Peter Hustings. You can go up here. I think there's a microphone.
First, I wonder whether the discussion has not moved from applicable law, conflicts of law, to transfers, BCRs, etc. And we seem now to be improvising our way in the cloud and the fog. Could I try to speak to the fog and the cloud?
Please.
If the company we are talking about in bullet point 2 is still the same company with headquarters in the UK and subsidiaries in various EU member states, as well as a number of other countries, then I would start by applying the theory which Locke used for the first bullet point, which we all agreed on. And she said, I remember, that the first criterion is the law applies of the establishment in the context of which the processing of personal data takes place. That means, in this case, UK law and various other EU member states. And as this is employee data, and we're not now in the case of the UK-operated website project, but it is typically, I would say, in the context of the employee relationship with local establishments, prepare for multiple EU national law being applicable. Let's assume Spanish, Swedish, UK, German. Then the next is, if EU law applies, the location of the data do not matter initially as to applicable law. So it continues to be applicable in the cloud wherever the facilities are. Okay? So either the company in London, alone together with its subsidiaries, it doesn't matter what their legal status is if you analyze the case, need to make sure that the cloud provider is aware of EU law applying. Now, under that arrangement, there is the transfer problem. And then suddenly it is important whether the data are in Slovakia or in the US and China. As to the Chinese, Indian, Singapore, and US employees, the case is completely different. And this is something we discovered in the first bullet point as well. But the finding that in the context of the activities of an establishment is the first criterion, that means that, say, the thrust of the case needs to be analyzed under that theory. Now, if there is no establishment in the European Union, then the means test comes into play for the scope of the case within European law. The rest of the case, different matter. And so there is more analogy between, and there is less fog, I would say. A great act, Vivian Arts, a great act, but there is much less fog than you think there is. So we need to apply it and then follow the line.
Yeah. Peter, you're very right. There's two additional comments I would like to make. The fact is that because the data is in the cloud and no adequacy laws apply there, you need to have adequacy measures, which will be the contractual clauses, and which you have to impose on your counterparty the processor requirements of the European Union. So there you go, it's a kind of export of European law there. But I agree with you, there's no doubt that just all European laws apply, and it's very difficult for a foreign US service provider to comply with that unless you bring it within Europe and comply in that manner. So that's, I think, where we were steering. Huh?
No, absolutely. And then the wrinkle there, which you mentioned, of course, is that for your affiliates overseas that weren't subject to European data privacy law, if their information is now going to go into your global database hosted by your service provider, where some of it is being mirrored, held, stored in a European country, then the European laws are going to attach. And then you need to remember that, because you wouldn't otherwise have applied those rights and obligations to that data.
Well, thank you for that. Let's move on to the next point. And I appreciate very much what Peter said, although I have to say, Peter, I wonder if there's as much clarity as you think, because I'm wondering if you're saying the EU laws sort of are attaching then to the data and then will govern, say, the processing of the data in China. I'm wondering, first of all, how do I explain EU laws to my employees in China, which seems difficult. I'm also wondering, because they have to apply the law there.
Let's not make it more complicated. The test is processing of data in the context of the establishment in Europe. So Swedish law, UK law, German law and Spanish law in this assumption. The establishment in China is a totally different matter. There, of course, EU law doesn't apply on that criteria. And in fact, maybe that part of the case is not dealt with by EU law at all, unless perhaps EU means are used. So in the context of the establishment in the EU is a very helpful guideline. Now, is this difficult? The cloud provider needs to follow the instructions of the company. So it goes to bargaining. And the controller is accountable under European law, already now, is responsible, so he needs to make sure that the cloud provider does only what he is told to do. That's the issue. Now, if the cloud provider has a secret agenda, then we have a problem. So you need to exclude that. And that is localizing cloud services. I think that's what Locke referred to. Doesn't mean that the processing is in a certain locality, but he needs to accept the conditions for which the controller will be responsible. And this is what the regulator will require from the controller. Okay?
All right. Well, in interest of time, let's move on to the next topic. Something very important that's been happening in the company is we have more and more requests from our compliance department. And Ariane, I'm really happy to have you here to help me deal with those questions. The compliance department is now asking that more and more data be collected about our employees and entered into the employee database. For example, they want records or they want to have indications of all of our employees who have a criminal record, that be entered. They're also interested if even the family members of the employees hold an important government job. And I've asked them, I've said, is this really a legal requirement? And they say, well, we better have this information available in case it's ever asked for by one of the government enforcement agencies. So this seems to me to be a conflict with data protection law. How would you deal with this?
Yeah. Well, Chris, I have to be honest with you. It's going to be very difficult. I don't know if you still have budget for this, because obviously you need to save for setting up an HR database in the clouds. But it's an area of high sensitivity because criminal records especially is very sensitive information. It's an area of high sensitivity, of local sensitivity also, because there are a wide variety of different requirements according to each jurisdiction, even in the European Union. And it's a massive conflict of laws, not especially between the laws of the European Union, even though they're different in this case, but with the laws of the US. And there is a real conflict of interest between US laws and European laws. So there are two issues, in fact, here. It's first collection of those data, of such sensitive data, and then transfer of such data to the US, since I assume that if you collect them, you will have to report to the US according to FCPA law. But the key issue here is whether or not you're allowed to collect them in the first place in the European Union. Well, to give you a flavor, it's going to be difficult everywhere, and in some countries it's going to be completely forbidden. It's not going to be possible at all. I have made Ruth and I have made a table, with all the different countries involved, and you can see that there are a lot of red and some orange also. But there is no, I'm using all my papers, but there is no green, which means that it's going to be difficult everywhere. So just to go into details, just give examples of what can happen, what will happen in different countries. First, in some countries, and let's start with the countries where it may be possible. So in some countries, perhaps you will be able to do it with consent of the employees concerned. This can be the case, for instance, in Finland. It can be the case in the UK to some extent, but it will not be possible for relatives anyway, whatever relatives are, because what does it mean? Does it mean family, by blood, by marriage? Does it mean contact persons? Does it mean friends? Anyway, if you rely on consent, it's going to be very difficult to ask the consents of relatives. So anyway, relative is going to be impossible in most countries. And the second thing is that even if you rely on consent, you need to be legitimate. You need to have a legitimate purpose for doing so. I mean, for asking people about their criminal records, or for asking to the police, like you can do in Finland, for instance, with the consent of people, and do a background check. You have to have a legitimate purpose, and you're selling consumer goods. So one of the questions here is that you would need to clarify whether or not really there is a necessity, even under US law, to ask people about their criminal convictions, whether there is a fraud, etc. Because you're not working for national defense or for security. You're not a bank, so. This also has to be clarified, even in countries where it's possible with consent. Now, in some countries, it may be possible with the authorization of the Data Protection Authority. It's the case in Sweden, for instance. It's the case in the Netherlands. I'm speaking about under the control of Peter Hustings, but it's the case in the Netherlands, and even in the Netherlands there is an exemption in the Data Protection Act which allows you to do so. But again, if you have legitimate purposes, if really you have to do it, and it's necessary, it's absolutely compulsory to prevent the interest of to preserve the interests of the company. So, and in other countries, in most other countries, it's going to be impossible. It's going to be forbidden because the laws of most countries provide that the employer is not allowed to collect personal data on criminal records unless it's provided specifically by statute. So it's the case in Spain. It's the case in France. You were mentioning Slovakia, for instance. Completely impossible in Slovakia. In France, it would be also impossible, and since I'm French, I cannot resist to tell you a little bit more about France on this. In France, first, you cannot access to any database on criminal records. It's impossible, it's forbidden by law. And if you asked an employee to give you whether or not he's been convicted in the past, not to mention the relatives, you would be forbidden by law, you are forbidden by law also to process such data, even by handwriting. It's completely forbidden. You cannot do it. And we even had a ruling from the Constitutional Court in France in 2004, which said that even with the authorization of the CNIL, of the French Data Protection Authority, it would be anti-constitutional. So really here you would have a big, big problem and you would not be able to do it. So since we don't have much time, and probably we will talk afterwards to try to clarify all of this, in order to, well, as a conclusion, I would recommend you first to liaise with the HR heads of each country, because there is really, it's really a local sensitivity. To liaise also perhaps with external counsels, okay. and also not to globalize, because it's really an area where you cannot go with a unique questionnaire which would say, for instance, a question like have you or your relatives ever been convicted? I mean, this is not a thing to do. It's an area of high sensitivity, massive risk of complaints to the data protection regulators if you do so. So not to globalize and go to each jurisdiction and check.
Okay. Thank you very much for this. This brings to mind something I think, Raphael, you said in your introduction, that it's quite possible that there can be a parallel track, I think you used the term, of law that goes along with, maybe it's separate from data protection law, but it can apply also with data protection law. And here it seems to me we have two different types of law, data protection law and other types of legitimate law, anti-corruption law, and they seem to be in conflict. And I suppose as regulators, you have to often try to deal with situations where there are these conflicts. How would, for example, the Spanish DPA or DPA deal or try to weigh these different conflicts of laws?
Yeah, you are right. And in fact, there have been some examples in the past. Perhaps we remember most of them. You mentioned before the SWIFT case, which is closely related. We are talking about security, and we are talking about personal data. There are other cases. For instance, I'm thinking about a transfer of PNR to the United States, which is, again, to legitimate, I would say, interest or rights, data protection and security. But the example that you give us here is really, I think that Viviane has explained the situation very well. I mean, it's at least in the case of Spain, it would really be a dead-end case. I mean, it's difficult to find a solution. Perhaps consent might be an idea, but the fact is that making someone to reveal a criminal record, and not only about him but about relatives, is really, particularly when we are dealing with a company which deals with consumers goods. So I'm afraid that I don't have a clear answer here in this particular point, because well, it's in Spain, as you say, it's the access to criminal records is restricted, and it's true, and in some cases happen that the consent is used. I mean, but no, I'm afraid that in Spain this would really be very difficult, if not impossible.
Loke, did you have a thought about the jurisdiction question?
Yes, well, because the data is processed from in the context of activities, as Peter said, of probably all your establishments, because they are applicants for all jobs in all the laws are triggered from a data protection perspective, and also all the labor laws with specific requirements are triggered. In the past, we have thought about solutions for this, and one solution we could think of is if you want to have a kind of, you have your central database for HR, maybe you want to launch a central application, you know, you're for applicants as well. What you could do is say, look, this central database for applicants is in the UK. This is an activity of the UK company only. It's not just an application for a specific job, but we ask people to, you know, online provide their application, ask just for the general questions, and then the moment there's a job which we think is you know, relevant, we can actually ask them for specifics and provide them and ask for additional information if allowed. And then you could centralize the law by having UK law, because it's only the data is processed then in the context of that, the activities of that establishment only. So you could get rid of a lot of laws by doing that, and you know, have your central database. So.
Yes, but not these laws, because they're public order. So in many countries, it would not be allowed just because it's a public order law. It's not only data protection. So.
No, I'm not. And then, you know, not put in the question, ask for your criminal records. But the moment there's a job, you say, look, this is a specific job. This is where we need, you know, specific information because it's sensitive. It's in your IT department, not in your marketing department. In your IT department, we need to know whether people have a criminal record. You check the country, if the vacancy is in France, and check whether it's allowed or not. If it's not, it's not. But still, to a certain extent, you could concentrate the applicable law for the first port of call, naming, you know, getting in the applications.
Okay, we'll have time for one quick question from Eduardo.
You probably don't need another lawyer, but I thought I would share a bit of experience with you in relation to transfers to law enforcement authorities or regulators in other countries. We had a recent experience for a client which would serve a wide subpoena by the SEC. And there is a myth out there in Europe where we believe that foreign or overseas regulators are going to be completely insensitive or are going to ignore any privacy or data protection related arguments. My experience is that if those arguments are well presented to the right people and they are solid and they're justified, they will be receptive. There is room for compromising, and I think it's not take it or leave it. I think it is possible to comply with both sets of laws, in my view.
Okay, that's a very positive note. I'll ask Eva maybe to hold your question for the very end because we have to move on. And this past question leads in, I think, very naturally to another final situation we have, which is really worrying me a lot. We have some customers in India, and we've been processing their data, and it's been transferred then back to the UK to our servers. And now the law enforcement authorities in India are demanding that we send them this data for anti-terrorism purposes, and they've threatened to actually jail the managing director of our Indian entity if we don't do that. And this leads into, I think, what is kind of the culmination of many points made here today, is that don't we need an international solution for these questions rather than dealing with a lot of national laws? I know the Hague Convention is an institution that has been promulgating many successful international conventions. So, Micah, let me turn to you and ask you for your thoughts on this point, and in particular in the context maybe of could we have some sort of international harmonized framework for some of these questions to avoid many of these conflict of law issues?
Sure. So to start off with, Chris, if you came to me with this issue, I would ask you a few questions. First of all, I'm assuming that it's a valid law enforcement request. It's not some renegade police officer coming and just demanding the information for his own personal purposes. You said it was for anti-terrorism, so it seems pretty valid to me. I would also want to know what sort of information they're asking for, and you mentioned that it's being stored in the UK. So then I would say, well, that sort of means that the EU Data Protection Directive would come into play. That being said, there's obviously a big conflict here. Indian authorities have been known to arrest and jail directors of certain multinational companies. So you really do have a problem that you should be concerned with. But going to what Eduardo said, maybe there's a way to sort of balance the interests here, to see if they can give a specific request. I'm assuming the information originated in India, but again, that might be something to think about. Whether there's any alternative means for getting the data. I mean, maybe there's a copy that's still in India that was never sent to the UK, so that you don't have to worry about EU data protection concerns. And also, to what extent would non-compliance put you in a bad position? What's going to happen if you do comply with the Indian request, and by virtue of that, you are violating UK laws? So you wanted me to comment a little bit on whether it's possible to have an international convention on this issue. At the Hague Conference, we focus on private international law, and unfortunately, that would limit us in this particular situation. It's more of a public international law issue. But assuming it was a private international law issue, I think that you do have a very good point. Over the last couple of days, we've talked a lot about how privacy regimes around the world are quite different. At the Hague Conference, we have other conventions. We have, I think, 38 since our statute was enacted in 1955 that primarily deal with administrative cooperation and applicable law or jurisdiction issues. So in other words, we try and bridge legal systems without trying to change them. In that respect, this could be a way to deal with a lot of the issues we've discussed here today. Coming up with some multilateral convention that would deal with administrative cooperation. For example, having a system of central authorities, which is something we have in some of our other conventions, and using that here. I know that they have obviously data protection authorities throughout Europe, but oftentimes cooperation outside of Europe, and even sometimes within Europe, cooperation is not at the level it should be. And so having a formalized system for that, and also having rules in place to determine which law will apply, so the law of the forum. An example of that would be one of our conventions. We have the Hague Abduction Convention, which basically does not deal with the merits of any case. So when there's a wrongful removal of a child, we don't care. But there are rules that say, okay, no, you have to go to the country of origin, for example, and those are the laws that apply. And so while we are still at the very early stages in sort of looking into whether something like this might be useful, it is something that quite possibly has some potential.
All right, well, that certainly sounds promising. It seems like the direction we should be going in. I know there was a question from the audience, because we're getting toward the end, so I'd like to take some questions. Ava.
It's not a question, I want to make a short remark.
Please.
Because I don't know if you have a subsidiary in Austria too.
Yes, and I love visiting Vienna, believe me.
I think so, yes. Thank you. Only a remark concerning the question of consent. So I think there is also a lack of harmonization in the interpretation of consent in Europe, because in Austria, I would say it's not really a free consent. So if I could give you advice from the Austrian Data Protection Commission, Chris, I would say please don't use the tool of consent in the field of employment data, because this, in most cases, this would not be a free consent. And so I have some doubts about harmonization in Europe, I think.
Would that also apply to job applicants? They are not an employee yet, huh?
Okay, this is also a borderline case, but I refer to the previous case with criminal records, of course.
Okay, but let's get back now to conflict of laws and jurisdiction issues. Are there any further questions from the floor to follow up, for example, on what Micah said? Yes, I see Jeroen ter Stege.
Thank you. I heard your comment on the child abduction rules. The problem that I think data protection has is that the primary process, let's say in your example, child abduction, that's the primary process. And then all the rules, the process that comes after it, that's what I heard you say, that follows the jurisdiction of the primary process. However, in data protection, the problem is that the primary process may be defined by some completely other jurisdiction than the data protection process. I give you an example. In Switzerland, there's a law that only applies to foreign employers. So the Swiss health and safety authorities want to have the data of the employers coming to Switzerland. Now, that is a legal obligation, and Switzerland is adequate, but I cannot, in my case in the Netherlands, follow the Swiss law. I have to find a basis in Dutch law to send the data to Switzerland. And those are the type of issues that we are having to deal with in data protection. We cannot use the jurisdiction on the primary process. Because in that Swiss case, I would just follow Swiss law and send the data to Switzerland.
Do you want to follow up on that?
Sure. No, that's absolutely right, and that's why this is still in its infancy. The example that I gave was just an example, and indeed we do have to come up with a good way to address problems like that. But I definitely see your point, and it is an obstacle that we have run into.
Yes, in the back there.
Thank you. I actually have a question. You mentioned an example of an Australian company having servers in Europe, and so European law applying. But what I've seen a lot, and it was just slightly different, is that it's, let's say, an Australian company that doesn't have its own servers in Europe, but has a service provider in Europe that's processing the Australian employer's employment data. How does the conflict of laws play out in that situation? Any comments?
Yeah, the question is, if you're an Australian company and you have a processor in the European Union, does the law of the European Union apply? Well, yes, the answer is yes. It applies because because the processor is going to process data in the European Union. So according to Data Protection Directive, it applies. Yes.
Loka, do you want to follow up?
Well, from a technical perspective, that is correct, because the connection point in 4.1c of the directive says whether you use means. I think it's time in this, virtual world to lose, technical criteria like that, like as a connection point. So I think we need to go to a more material connection point, which would be, I think, whether it has any relevance to the jurisdiction here, and like that, that it's not so much processed in the context of an establishment, which is already a legal concept, etc., but like in the context of activities here in Europe, which would get rid of that, technical requirement, and I think then you would have solved that problem in the sense that these data are they processed in the context of an activities of a company here in Europe? No, it's the Australian company, which would get rid of European laws and not attract unnecessary laws to foreigners.
Yeah, I agree with you. I agree with you that it's a big problem, but the interpretation of the directive is varied also depending on the jurisdictions, and some data protection authorities consider that even though the people who are whose data are being processed are outside of the European Union, the fact that you refer to a processor in the European Union makes the laws of the European Union apply, which as Chris, you were saying previously, how do you apply European law to Australian people? Because if European law applies, it means you will have to inform Australian people of their rights according to European laws and etc. So I completely agree with you that it's something that should be solved from a practical point of view.
I think actually some DPAs have indicated that in their opinion, this is not a desirable state as well, and that they won't go after companies like that. But that is what I don't like about it is that it is dependent on individual policies of individual DPAs.
Yes, the German DPAs, for example, have published a paper indicating that if the data are encrypted in Europe and they cannot be accessed, that's what they call a black box solution, then it would not apply. So there are some interesting trains of thoughts. Any further questions before we end? I will turn to this man back here because you've already asked one question. Sorry. Go ahead.
Oh, hi, Bob Lindsay from HP. I was just, as a follow-on to the previous question, I'd be interested to know that once that service provider has the data in Europe, how it would be able to legitimize a transport of data flow outside the European Union again, because there is no instrument which allows a processor to legitimize that transfer. So once it's here, can't go anywhere, no model contract works.
But in that case, they would not be able to transfer the data unless it was under the instructions of the controller, and the controller would have to find a mechanism that would be compliant with the directive to transfer it outside of Europe.
Yeah, but the model contract, correct me if I'm wrong, assumes that the data exporter and data controller is established in an EU member state, which it wouldn't be in this case.
Well, maybe on that, maybe that's a good note. Or Locke, do you want to have the last word?
I think the EU model contracts do not assume that the controller is established in the EU, but just that one of the establishments is here, if that is the connection factor. If there's no establishment in Europe, it's the connecting factor is the use of means. So there you go. But you're right about the processor, the main processor being in Europe for application of the model contract. My point of view would be that if the data protection laws do not apply, then it can be transferred. And Australian law would govern the relationship if it goes to a country that is inadequate in the views of Australia. Their laws will govern them that route.
I agree, and I think on a
Vivian.
practical level as well, a lot of companies end up segregating databases out so that they don't have non-European data held in Europe because of this. I think often data privacy is regarded a bit like a virus. It attaches to the data as soon as it comes into the EU, and then you've got the virus, which is quite unhelpful, and you end up with these convoluted models to get around it. And then practically, ultimately, when the data from overseas is in Europe, technically the individuals outside have the ability to enforce their rights within Europe. The reality is there's nobody in Costa Rica or California or Australia is going to have any feasible way of actually achieving it. So it's a bit of a nonsense. It would be great if we could have some clarity.
Well, on that note, we're at the end of our time. I'd like to thank very much the panelists. I'd like to thank all of you. Enjoy your coffee break then. Thank you.